Okay, so our plan today is to do something a little bit different, which is to just talk about our favorite cases of the week. And we also, I wanted to share a new kind of strategy that I have decided to employ using, well, I'm trying to find a tech tool that I'm going to use this for. So I'm putting this out there as a new idea that I have for how I'm going to practice and maybe even open it up to people as to whether or not they have similar strategies that they are trying to use AI for, and see if other people have ideas that they want to share with us.
Yeah,
So,
there's been a few consultants that have approached us asking if we could do more case updates, which we plan on doing. Another idea that Deanna and I have had is starting a Slack channel to sort of build a bit of a community. We right now have a few ad hoc signal groups that we currently post in, but some people have thought that a formal Slack community would be neat. So and more, I mean, I'm not sure what form this would take yet, but if we could use the podcast also for like as a or the Slack channel as a way of fostering mentorship. So Deanna and I are
mm,
currently, we're thinking about how to implement those requests. But for now, yeah, we have three to four cases, I guess from July that we decided we would just review and discuss in some detail today because they raise interesting questions beyond the cases themselves, and I think would be beneficial to basically anyone preparing an application who finds themselves in this situation. So why don't we dive in?
just to go back to this thing that you're saying about the sort of thinking we're doing about the kind of big purpose of the podcast and what we're trying to achieve. What I've been finding, and I think you're the same, Steve, is that over the last little bit, the kinds of problems that I'm encountering in litigation, and even just in general practice, they're so they're so much more complicated. And that now I think we've all been kind of sent into a situation where most of us are working in either small firms or even in sole practice. And, some of the larger kind of litigation firms have sort of splintered off. It's very hard to run a profitable litigation practice right now. That's something that we're all kind of experiencing, I believe. But because of the complexity of the cases and because of how quickly things are changing and how processes are changing, the need to like sit down and talk through like, okay, so have you tried this? Like, what is the timeline going to be? What do you do when you get this kind of emotion? Like, have you done this before? Like, really actually needing one another, and particularly because the department has so many resources for collaboration and so many different access to different tools and that sort of thing, that like we need to do the same thing. And so that's kind of what Steve and I are talking about trying to foster through the use of just mentorship, because young lawyers trying to figure out how to do this sort of thing, and they're operating in smaller or solo practices, but just like being able to like share these resources, share these tips, in a public forum like that, or a
Yep.
closed
And at
forum.
the same time, I do also like as the podcast audience has grown, I sometimes get just people saying, "Hey, what do you think of like Jordan Peterson having to do self-education for breaching professional ethics? Do lawyers have that? You should do an episode on that. Hey, what do you think about the new hate speech legislation that Canada has? Like, how will that impact immigrants?" So I also like all of those are also interesting topics. So it's
Mhm.
if you do have any like, insight or requests as to some upcoming episodes, definitely let me know. We do have some, good ones coming up. And yeah, I did think a Slack community and more of these, I guess, hard law updates as well.
Yeah, for sure. Do you
Um,
want to start with one of your cases, Steve?
yeah, this is a case. The case name is Toor, spelled Toor, v. Canada Citizenship and Immigration. The neutral citation is 2024 FC 1146. For those who don't know what a neutral citation is, prior to neutral citations, I guess cases were all kept in big books. And in order to cite a case, was very, very long. And the neutral citation is just a way of identifying the case that's very short. So this case involves an individual who fell out of status while a permanent residence application was in process. And if someone, and Deanna's just for those watching on YouTube, has loaded the case up. So she fell out of status, and if you fall out of status, you have 90 days from the expiry of the status to apply to restore it. This is called a restoration application. And that's kind of the basics that I think most people who are familiar with immigration law would know. This case gets into some of the complicating issues of restoration, such as what is your status during the processing of a restoration application? What are the consequences that can happen to someone with a restoration application and process? So in this case, a visa officer sent the applicant a letter stating that they were out of status and they needed to provide proof that they had left Canada in order to continue processing the application. The applicant responded to this application or to this letter by stating that she had applied for restoration of status and that the application was in process. The visa officer then refused the file, stating that they had sent this letter stating that the principal applicant needed to leave Canada and that instead of leaving Canada, the person had just said they were applying for restoration. Therefore, they were out of status. Therefore, they were going to refuse the application, and they did refuse the application. So Ms. Toor sought judicial review, and the federal court set aside the decision essentially on the basis that the officer hadn't adequately explained why they were not taking into consideration the fact that the principal applicant had a restoration application in process. What I caution and note about this is that the decision was set aside, but that doesn't mean that it's necessarily going to be the case that this person will have their application approved if they don't leave Canada. The judge doesn't say that. They just say the officer has to consider it. And the reason why I find this to be the case that I wanted to bring up today is that I do find there's a lot of confusion around restoration applications. In this case, I'm not sure that people fully understand that, yes, IRCC will process someone's restoration, but it doesn't mean they're in status for the purpose of a permanent residence application. And it's separate from this case. But the other thing that I just think people should note about restoration is it's also not a shield or a full shield to CBSA removal just because there's a restoration application in process.
Mm.
So,
There's actually there was one case that I argued at the very, very beginning of my career where the justice did some talk about restoration, which is that like you're considered to have like broken the law, but at the same time there's a way of fixing it if you do it within the time period. It is a weird little space, this period of restoration, but you don't have maintained status. What you have is we don't know what, but it is it's just like, it's the period where you can still cure the non-compliance. But you're right, it is kind of a limbo land. But I think the thing that you bring up too, Steve, is just this idea. I mean, we talk about judicial review all the time, but the idea that a decision that is successful on judicial review, this does not bind the outcome for a further redetermination by the department. That like you can win a judicial review, and this is what makes it so challenging for clients, is you can spend the time, spend the money, you win the application for judicial review, usually thousands of dollars in terms of legal expenses, goes back for a new decision, and then they can refuse it on alternate grounds. And
mhm.
so, and unfortunately, this is something we are seeing with maddening frequency lately. So, anyways, that's a throwaway point, nothing to do with this
Yeah, and
case.
we're not saying that this application necessarily for sure will be refused on
No.
redetermination. I've had situations actually where I have a client who's got a restoration application in process and a PR application, And I've gotten calls from visa officers being like, "Hey, just so you know, I'm going to exercise H&C." And I'm like, "Oh, sweet." So it doesn't mean that the application will be refused. It's just important to note. And from what I understand, actually, in speaking with some other lawyers, there's a flurry of like PFLs, procedural fairness letters, recently on this issue of people with restoration applications in process or TRPs in process. And the permanent residence application officers are sending PFLs going, you've got to leave Canada, which, depending on the program, may actually jeopardize the application.
Yeah, I'm unfortunately seeing a lot of these with caregivers. And unfortunately, these are a lot of cases involving caregivers who have applied under the home child care pilot or the home support worker pilot, many of whom thought that by applying for permanent residency, they had effectively extended their stay legally. And now, after 1 to 2 years of delay, IRCC is writing them a PFL saying, we have determined that you have lost status. You have 15 days to respond. Um, so
Yeah, I mean, that's an ongoing, you know, and I mean, this is going to be a very short rant. Um, but like, and in the, we recently dealt with something somewhat similar in the Inside Canada spousal sponsorship application, where you can apply for an open work permit. And it used to be the case that you could include the open work permit application with the permanent residence application. Now it has to be filed separate. And the current public policy for the open spousals explicitly states that if you just attach the work permit application to the permanent residence application, it'll be returned. And from a bit of a, I don't want to use the word common sense because there may be an argument for why you shouldn't be able to do it. But I feel like from a resource management perspective and avoiding those scenarios like you're talking about, where someone applies for permanent residence, most of the programs come with the ability for bridging open work permits. Why those have to be applied separately instead of just being able to be applied for at the same time,
mhm.
or even just including a fee to
Yeah.
get that open work permit, and why there needs to be separate paperwork
Yeah.
is
I
a
actually remember when
disney.
I very first started practicing, and I think it only lasted a few months, that when I was in the not-for-profit sector at the time at the West Coast Domestic Workers Association, there was a permanent residence form. When you filed a caregiver permanent residence application, there was a box at the top that said, would you also like an open work permit? And you just checked the box. And so I was watching in a news segment this week about, how difficult corporations have made it to unsubscribe for things these days. And it kind of feels like the same issue is happening with immigration. Like the service is made more difficult to obtain at all times. Like if you want a TRP, you need to do it by mail. You need to print the forms, you need to sign them, you need to create a physical photograph, like all these things that, like, why can't you just apply for that online? Why can't you say, like, yes, I need a TRP, like why? And it's almost like by making it more difficult. It's the same thing with an LMIA. By making it as difficult as possible, they hope to deter people from requesting it. To me, that's the only possible rationale as to why this open work permit and the permanent residence application have been severed.
Yeah. Well, and the other example, and I think we've talked about this on the pod, is you apply to extend your work permit, and once your work permit is approved, you can then apply for a visa to travel. And the only requirement to be approved for that visa to travel is that you have the work permit, but you can't just do it at the same time or click, here, I'll send my passport in. Or
Yes.
even just like, I know they don't want in person, but I don't fully understand why you can't just take your work permit to a human and
Yeah.
say, hey, can you, I mean, this is going to get into also like, why do we still have physical visas when the
Yeah.
technology for electronic travel authorizations exists? But anyway,
For
we've kind
sure.
of like
Yeah.
Kind of gone
Steve
on a
has
bit of a
gotten to
side.
the point, Steve has to like cut out rant portions of there's a very hilarious one that's circulating now of him having cut out 2 minutes of me just going off in our last
Yeah. Yeah.
episode. So yeah, anyways, we will digress, but yeah, so I think
Yeah,
that that
big
is
takeaway, the ratio of why we discuss the case, restoration. Don't assume that just applying means all problems solved
mhm,
for PR. Case
yeah.
number two, which is a big one. If you've got a Hong Kong clientele, from what I understand. Chung v. Canada Citizenship and Immigration Neutral Citation 2024 FC 1218. Chung spelt Chung. So this case comes in to an issue that apparently is all the rage, or at least in the media in Hong Kong, which is that Canada and several other countries have work permit or immigration programs for people from Hong Kong, provided that they have meet certain education requirements. So apparently what's going on in Hong Kong is there are allegations of people being able to buy degrees. That's actually the big one, is people who are just able to buy degrees, essentially getting degrees for the purpose of meeting this program. This case does not address that issue head on, but it involves someone who applies for the program and they have a degree from one of these schools that may or may not be possible to buy a degree from. And at the interview, the applicant says, well, I didn't buy my degree, but I did like plagiarize and copy other people's work entirely, like for the entirety of the program. The data that they used was fake, or that's in the from the decision. The data and statistics they used in their thesis were fake. They admitted that the prerequisite degree and thesis for their MBA was plagiarized from other papers. But they do wind up getting this degree from the school. And a visa officer refuses them for misrepresentation, for having obtained a fraudulent degree, and the federal court sets it aside, stating in paragraph 14 that there wasn't enough information before the visa officer as to whether the degree is actually fake. And that it appears to be, as you can see in the bullet points from paragraph 13, that Hong Kong authorities seem to recognize the school, the University of Sunderland, as a legitimate university, um, and that it wasn't reasonable for the officer to say that, to jump from you plagiarized a lot of material to get your degree to the degree being awarded on false pretenses, and that it wasn't reasonable for the officer to foray into whether this degree is like a fake degree or not when it seems real. They can't, that's a school problem or an applicant or a Hong Kong problem regarding whether the applicant should have gotten his degree and whether the school is real. And why I find it interesting, A, seems like, from what I understand, there's a lot of people who are getting procedural fairness letters who attended this school and other schools. And B, it forms some parameters around where IRCC's analysis and ability to assess misrep ends. There's another case, I can't remember the name, where someone provided false transcripts to York University to get in, and IRCC somehow learned and said, well, you committed fraud to get into York University, therefore you committed misrepresentation. And the federal court said, well, that wasn't in an immigration application. That's a York University problem. You can't find misrep there. So it's interesting to see where the outside parameters fall. The big one that I've always, and I haven't seen any cases on, and maybe PMP, if you misrep to the PMP, are you aware of any situations where IRCC comes in and says 5-year ban for having committed misrepresentation to the PMP? I've seen PMP letters where they're like, you committed misrepresentation and we're going to show this to IRCC,
Mhm.
but it's not clear to me what the actual consequences of that are.
I don't think I've seen a decision where it directly led to a section, what is that, 40?
Yeah.
40 inadmissibility. But I can imagine that it could, because had the BCPNP not caught it, then it could cause an error in the administration of the act. I've just not seen a reported decision where that was
So where
actually
would you think the line between like it's not misrep to lie to your school, but it might be
because
misrep to lie to the PMP?
that is directly part of the immigration process, right? The nomination from the school would then actually be communicated within the
Or from the
immigration
province, nomination
scheme.
from the province.
Sorry, from the province would directly, like, it's part of your actual immigration um determination, I
Yeah.
think.
I don't know.
I mean,
If any of the
I don't
listeners
know.
have seen cases on this,
Yeah, please.
definitely
Would be
please
very
reach out
interested.
because it's something I thought about both after the York University case and then this case. And
Yeah,
I don't
definitely.
know.
And I think that the other part that I think um that case reviews are and also just these public forum discussions are revealing is that I would guess like something like 90% of cases are still being settled before we get decisions from the court. And so there's a lot that
Hmm.
we are seeing reported, but a lot more that we're seeing that gets resolved well before it ever sees the courtroom steps. And so there may well be people that have dealt with these types of situations and can tell us what has occurred that was
Yeah.
never a reported decision. So we are very keen to hear those types of situations too.
Yeah, definitely.
Mhm. That would actually be something very interesting to talk about, the unreported, the settled cases, because those are generally some of my most important learning tools for myself. Well, I tried this and this is what happened and we resolved it. Yeah, but
Yeah, and
people don't
there's
have access
I
to
mean,
that.
and there's whole swaths of immigration that don't wind up with public reported decisions. Almost everything that goes on with CBSA
Well, yeah, and
never makes it to court.
everything before the R, like, I mean, most things before the IRB, not most, but like, some of my best outcomes at the IRB are never reported decisions.
Yeah, that's part of why I share the A tips because they also have nuggets.
Yeah, definitely, definitely. Unless they go up to the federal court. A lot of very interesting decisions at the IRB just don't end up reported.
Yeah. Last case, I think, and it's one of Will Tao's.
Oh
Um,
yeah, this one was disappointing to me.
this one was disappointing, but I think expected.
Was it?
Or,
Nah, not for
well,
me.
I mean, actually, and I
I've
mean,
had
this will
different
preview the
outcomes
case.
than
We're going to
this.
have Andrew Hayes back on the podcast to discuss different U.S. refusals and what
Right.
constitutes a refusal in the United States, because um, there's it's becoming an increasing issue, and I know that immigration lawyers in the United States are increasingly being contacted. So in this case, we've discussed kind of, I think we've probably indirectly touched on the issue that this case raises, which is the immigration forms ask if someone has ever been refused a visa or refused entry to any country. And it raises the question of what does that mean to be refused a visa? In this case, the person had gone to the United States and,
What's the neutral citation, Steve?
oh, neutral citation. Oh, the case, Abdool, Abdool, v. Canada, 2024 FC 1172. So the person goes to the United States and is stopped by Customs and Border Patrol. And after an interaction there is told, you won't be coming in today. We are going to allow you to voluntarily withdraw or cancel your attempt to enter the United States.
Right.
Um, and the issue then is, does an attempt to enter the United States that was voluntarily canceled, which is the words that the US uses, does that mean someone was refused admission such that they should be banned from Canada for 5 years if they don't disclose it in the application. And in this case, the person had actually disclosed a previous visa refusal. They just hadn't also disclosed this incident. And the
Unbelievable.
court found that it was reasonable for the officer to essentially read in voluntarily canceled into the question, um, or at least read in refused admission includes voluntarily canceled. So you were surprised.
I think this is bad law. I'm sorry to
Oh, I
say.
agree
Like,
with that, but like
yeah.
with it's and why
I
do you think it's bad law?
well, first of all, because I mean, we have um I just don't think that the case for materiality can be made out here.
Hmm.
Like, I don't
Well,
understand
you
how
should
that
probably
could
elaborate what
possibly.
that means. What does that mean in
Okay,
the case
so
for?
in order for misrepresentation to be made out, it's not just that there was an error or omission, it's that the omission or error could have led to an error in the administration of the act. And to me, I don't think that there is any nexus between the failure to disclose, that voluntary withdrawal, and them not being able to conduct a proper, that them not having the information before them that they've required in order to be able to conduct that investigation. The other part about this is that in certain situations, like for example, when somebody has failed to disclose a Canadian refusal, the department has held that you can't be found inadmissible for misrepresentation when the material was already before the officer. Now, when they're doing these refusals on the basis of US refusals, I'm starting to feel like we're at the point now where those US refusals are already before the officer. So to like, I just don't understand why they're making so much hay out of this US not disclosing US refusals when that information is clearly within the possession of the department. It feels like a gotcha. Like, this is now a new way for them to catch people. um like, if this information were publicly available, you could see it on the website. Is this correct? I mean, people come to me and they say, yes, my consultant, my lawyer filled in this form. I looked at it, looked right to me. I signed it. I can totally see myself having somebody else fill a form for me and be like, yep, that looks right, forgetting that I had tried to go somewhere and then I'd forgotten to pay a fee and then it was refused. Like, these are accidents, they're not intentional misrepresentations. And so, again, so I'm mixing up now materiality with an innocent misrepresentation. We do have that Muhammad case that we've talked about with
Yeah.
Raj saying, like an innocent mistake. But anyways, this decision found there was nothing innocent about this mistake. Even though it was really about this kind of delicate interpretation of, does a refusal include a voluntary, like, to me, that creates an innocence around the non-disclosure. And also, I just don't see how this is relevant to them finding out something that was in any way relevant to determining whether or not there was some inadmissibility against this person. It's just a gotcha to me.
Yeah, yeah, here they found that it wasn't innocent because they knew that they had the visa voluntarily canceled.
So there it is, right there,
I
paragraph
like
32.
I just where I come down on this is, and I've made arguments successfully in different contexts, not in the refused entry or the question to be on the forums, but like the department writes the forms. Like if they want the word voluntarily canceled to be included, change the form, right? Like add it to the form. I don't think applicants should be expected to know that refused admission is being read into canceled visas. And there are now a few canceled visa decisions where it's basically you read it in. The form doesn't say refused, it uses the term canceled, but it gets read in. And I just have a problem banning people for 5 years
I know.
because they didn't know that a term was being read in when that department can just add the word to the form and it would catch this. Because Canada
Yeah.
is the same thing, a voluntarily, like CBSA, you'll come in, CBSA will say, well, we're going to write you an exclusion order, we'll ban you from entering Canada, or you can sign this form saying that you're voluntarily withdrawing your attempt to enter Canada.
Mhm.
And to me, that process means someone voluntarily withdrew.
Yeah.
It may be that you can say, well, that voluntarily withdrawal looks like a refused admission, but there's a big legal
It's
difference.
not.
Like it's a
It's
legal
not.
difference.
Yeah.
So if they want it to be included,
Include it.
change the form.
Yeah.
That's basically where anytime where there's this ambiguity, big time ambiguity over whether something should be read in, and one side can literally edit a PDF to change what the form says,
I
and it would
know.
resolve all this. Like,
Yeah.
yeah.
I
I also
know.
get
I
really
know.
annoyed by the jurisprudence, which, like, I mean, I feel the same way about if a document is not listed in a checklist as being required. For example, in truck drivers from Dubai, because of all the case law, most truck drivers from Dubai will know that they have to include their driving record from Dubai. Um, and there are
And that
cases
you
over which is
must
the
have a
proper,
language test.
yeah, and
Yeah.
there's cases over like which is the proper driving record to enclose, and the standard Dubai criminal record check doesn't cut it. And applications can get refused right away. Oh, they didn't include the driving extract. And you're just like,
It's a
why isn't that on the
requirement.
checklist? Like, put it in the
Yeah.
checklist then. I don't know.
Yeah.
It's just,
For
it's
sure.
weird. While at the same time, the department, you don't need to hire anyone. Um, yeah.
And I mean,
So,
similarly with like, if you have to have a CLB5 to drive a truck, then say that there's a CLB5 requirement. Don't make people, go and, apply. There's no language requirement established by by anything, and then
have we
have
done an
them do
episode on language requirements and work permit refusals?
sort of, we've talked about it on episodes, but we've actually
Yeah,
never
maybe we
done
should
one
do it.
on
It's
that
one of the most,
specifically.
we have an articling student who in law school did their like thesis or main paper on this topic. Um,
Yeah.
it's so, I don't know. I feel like I must have gone on rants. I know I've gone on rants and consultant presentations about the bizarro world of and how arbitrary the language requirements for work permit refusals for truck drivers are.
We
Doesn't
talked
help
about this
that
a little
British
bit.
Columbia has all those trucks driving into overpasses, but I don't know to what
Yeah.
extent language plays a role with that.
Exactly. We talked about it a little bit when we talked to Michael Green.
Yeah.
And so, but again, like it's not being focused, but and now I'm finding it coming in on hooks. And so like, anyways, I have one of these cases that I've currently, I'm grappling with. But I mean, in terms of this question about the US non-disclosed thing, I mean, I know I've talked about before that my client was facing an admissibility allegation on the basis of not disclosing a refused ETA, a refused Canadian ETA. He disclosed all of the circumstances that caused the refusal of the ETA, and he disclosed the refusal of the work permit, but by not, and the ETA, as I argued before the board, is not a visa. So it's again very similar to the case that you've just covered, because it doesn't say it says have you ever been just refused a visa? And as I argued before the board, an ETA is not a visa. It's an electronic travel authorization for somebody who's visa exempt. So the question doesn't ask, have you been denied a visa or an electronic travel authorization? Again, this information was before the department. They were the ones that refused it. He had provided all the facts that caused the refusal of his work permits, and he mentioned the refusal of the work permits. But at the board, he was found inadmissible for misrepresentation, but then they ended up allowing the application on humanitarian and compassionate grounds. But again, it's impossible, in my view, to reconcile the jurisprudence right now that an ETA, like how that could have been
Oh, it's super
material.
unlike, it's
It's super,
super, the jurisprudence is a bit all over the place, but also the principle is like
the principle is
the,
untenable.
the most extreme example of like how confusing and different opinions misrep can be was I remember doing a continuing legal education in front of a group of like half private bar, half government. And the question was, okay, if you 10 years ago, 5 years ago, whatever it is, you think you may have driven drunk home, but you don't actually know for sure, and you were never caught by the police. You're just like, oh, was I drunk? Do you have an obligation to disclose that when you're entering Canada? And they're like, anything to declare? Why, yes, officer. 5 years ago, I had some beers and I may have driven drunk, but nothing ever came of it.
Yeah.
And half the room raised their hand saying that that doesn't have to be disclosed. The other half raised their room saying it had to be disclosed and it would be misrepresentation not to.
Yeah.
And that's a little bit different because here there's like, it's more an interpretation of whether you should be reading in words to
Yeah. Well,
words that aren't in the question. But
what about you were smoking weed at a period of time before weed was legal?
yeah, right. Like there's all, and then the question is, have you ever committed a crime?
Yes.
Yeah. There's an interesting, we should like, there's a whole philosophy about how the government almost exists to make everything a crime so that they can get you at any point if they choose
Yes.
to. And I feel like this is a classic example of that philosophy.
Yeah. There's one more case that I wanted to discuss, and I don't know if we should just save it for another
No,
day.
no, let's do it. Let's because there'll always
Okay.
be more cases.
Yeah, exactly. So the one that I wanted to discuss was the Lee case that you and I chatted about with Lev on our Slack. So the
Signal. But
neutral,
yeah, we'll start a Slack channel.
yeah, on our
Again, message
signal.
us if you have ideas about what you'd want in a Slack group.
Okay.
What's the
So
neutral site?
the neutral site is 2024 FC 913. I think. Oh no, wait, I just we'll
Yeah,
confirm it's
Lee.
correct. Yeah,
Lee. It's
yeah,
like my
that's
middle
right.
name.
That's your middle name.
That's my middle name.
We learned something new
Named
every
after
Tuesday.
Bruce Lee, if you can believe it.
Are you serious?
Yeah,
That's actually kind of adorable, Steve.
I'll take it. But yeah,
You
it
and
is.
your jujitsu, that's why you're such a
That
jujitsu
must
master.
be where it comes from.
That must be it.
Yeah.
Okay, so this case to me, I decided that I wanted um, to declare this proof that we are kind of entering this theater of the absurd kind of period of immigration. This was about um, the request to be granted an extension of time. So I don't know if everybody here also remembers the period of time when, you got a letter and they gave you 30 days to respond and you needed an extra 30 days. So you wrote to the immigration department and you said, I need another 30 days. I will assume that this 30-day extension has been granted. And unless you write back to me, I'm going to assume that my new deadline is such and such a date. And you pretty much never heard back. And so you would just go to that new extension date. What I'm finding very frequently now is that rather than being given 30 days to respond, you'll be given 5 days or
Mhm.
7 days to respond. And not again about like, can you please provide us this specific document? But for example, can you please provide us 2 years of financial documents belonging to your employer that is like the employer that you wish to have to employ you as a caregiver. So these are personal financial documents belonging to somebody who is not you. His children's birth certificates, and we're going to give you 5 days after we've been waiting. You've been waiting 2 years for us, and so very very tight timelines. And so then you request an extension of time, and very often now they'll say, no, we won't give you that much time. We'll give you 10 days more. And so this is just the new environment where the department will take 2 years, 3 years. You might bring a mandamus application to try and get them moving. But when you request time, the requests for extension are sometimes denied, or they're actually circumscribed how much time you can get. So this case involves somebody who was making a study permit application, and the lawyer who was representing them asked for an extension of time to be able to respond. And the visa officer said, no, I refuse the application. And so then what happened is that the lawyer asked for reconsideration and said, the reconsideration is that the reconsideration request is that the refusal to grant the extension of time was a breach of procedural fairness. So we're asking you to reconsider it now. To which the visa office replied, and I think it must be here somewhere.
Yeah,
Here. It is now February 23rd, and the remaining documentation still have not been provided. And so the refusal still stands. So basically, it was like they had taken the perspective that an extended period of time had been granted, but you still haven't complied. Uh, so, so basically, then when the case went to the federal court on judicial review, the lawyer was arguing breach of procedural fairness. And the Department of Justice tried to argue that yes, the original denial of the extension of time was a breach of procedural fairness, but that because the officer had been prepared to accept new materials, as demonstrated by their response to the reconsideration request, that there was no breach of procedural fairness, which to me is just simply mind bending. We've
yeah.
refused, but had he sent the reconsideration request with the materials, then that point they could have been considered, which of course wouldn't have been known to the officer or to the person because there was a refusal. So this kind of mind bending thing and the fact that these types of arguments are being even raised, no settlement was offered. This person had to go all the way to a judicial review. And fortunately, it was found that the officer's reconsideration decision did not cure their procedural fairness breach of failing to consider the applicant's request for an extension of time. So it was a good outcome. But ultimately, the fact that this person had to go all the way to a federal court decision in order to get this result is to me pretty egregious. And this is sort of the type of thing that is taking up the court's time, taking up the resources of the Department of Justice. I'm just sad that these sorts of applications are being opposed. This should have been a consent from day one, in my view. And so I'm not trying to personally attack anybody in saying this,
Yeah.
but this is just kind of this is a demonstration of the types of things we are seeing, that to me are they're illustrative of what kind of situations are coming across in the
Reconsideration requests are like the jurisprudence on them is all over the map about whether there's
Mhm.
one test or two, what the
Yeah.
standard is in the two tests. And the
The
only
reason this
like
came up actually, though, between us, and I don't mean to cut you off, Steve, but like one thing, the reason that we started chatting this on our Signal group is like when you make a reconsideration request, you got to be clear why you're requesting it, what's
and
preventing
include the
you,
documents if you can. Like I always tell
as
people to
much as
get the
you can.
documents. But
Yeah.
I also understand the other side, which is like if my file's closed, can I even be sending documents? I think is also a perfectly reasonable approach that someone may had. I also do think that like, you know, the overall structure, if I were, this isn't even president of the Treasury Board, this is just the reconsideration request, in my opinion, should be more broadly looked at just in order to reduce the amount of judicial reviews, right? Like if there is the scenario, especially in a world of web form inquiries, where extension requests might not be getting properly added to applications, the reconsideration for these the avenue should be reconsideration
Yeah.
that is just flexible instead of now I got to go to court because it's not clear what the test for reconsideration will be. There's actually a case just today um, on reconsideration that I was sharing with the firm because we have at least one JR on it on the go. And the neutral site is 2024 FC 1270, Kong, Kong. The issue there was like the reconsideration request is kind of similar, where somebody was asked to send in documents. They did send it in, but it looks like it never got added to the file. So the file was refused. they submitted a reconsideration request saying, did you guys see the correspondence that I sent that you're saying wasn't provided? And all the reconsideration refusal said was, your application was considered on its substantive merits and
Yeah,
was
that's what they
refused,
always say.
therefore
I
the
can
refusal is
repeat this.
upheld.
Yeah.
And it's again just an example of like, given that there are recognized issues with documents and web form inquiries being added to files, did this need to go to judicial review, or would the better approach not just be, okay, well, it looks like it was sent into the netherworld of case-specific inquiries.
Yeah.
So we'll show some flexibility here. And in this case, again, the refusal to reconsider was set aside.
I think that you might have misstated the neutral citation because I couldn't find it. 1270?
Yeah, 2024 FC 1270. Might not be in Canley yet. Um,
No,
but it's
it's
on
not.
the federal court, IMM
Okay.
460122.
Okay. It's just not on Canley yet. So,
Yeah,
by the way, Canley, www.canley.org. That's where we find all of our, like, it's for free, and you can find all your case citations there,
yeah.
as well as the federal court website. But Canley's really good. Um, so, um, but in terms of this reconsideration request subject, um, that letter that we've considered it on its substantive letter merits, I got so many of those that I got sick and I stopped sending reconsideration requests. But I think because of this new environment, what I've started doing, when I said before that you needed to document why, what I meant was you need to document when you're making a request for extension. When you're saying, I want an extension of time, you need to be specific about why you need an extension of time, not just like, we need an extension of time. We need an extension of time because these documents are not in the possession of this person. Here's
Mhm.
where we need to get them from. We already made this request. If they think that you're just waiting until the last day to request and try and get the documents, they are more inclined to not request it. So you need to substantiate your request for extension in a way that you didn't used to have to. So be on notice about that. If you've made the request, you might even put in proof that you've
Yeah,
made the
yeah.
request in a timely way. You might give an estimate as to why you think, any kind of proof you can provide as to why you think it's going to take as long as it is, if there's some published processing standard to get that document that you think you need, because otherwise, you could be denied. The reason I think it's important to make the reconsideration request now is that sometimes you can end up JRing both the refusal and the reconsideration request. But be warned, do not just JR the reconsideration request, because then you may not get at if it gets reopened, all you've reopened is the reconsideration.
That's
You
a
need
good
to
point. Yeah.
JR both, and then you can consolidate so that they get heard together. But do two JRs, seek consolidation by consent, and then that means sometimes, like, again, you need to be careful about the deadline. You can anyways, but more detail on that could be provided. But I think that's just the general broad strokes.
Yeah. Yeah. So those are four recent cases. Gives an
Yeah.
idea as to actually what we do. I'm curious to hear the feedback.
Yeah.
You also had was it a vegetable that you wanted to talk about or an AI tip?
No, no, I'm going to leave my vegetables for a different time. I'm just obsessed with gardening right now. This is the way that I'm keeping my brain together. But with all this craziness, the AI tip that I sort of just came up with, because those of you who use Zoom have probably noticed that suddenly Zoom creates AI transcripts, but only
Mhm.
when you record the session. So if you just have a meeting on Zoom, it will do a summary. But if you record the session, it now creates a print transcript, which is great. I currently have my IT people looking into, like, what are the security issues around that print transcript. And so maybe on the next session, I can report back for what my IT people have said,
Is when they
because
come back and they're like, it's all shared with Xi Jinping.
exactly.
But
So
then
that's a
so is the
little bit,
convo on Zoom probably. So
probably. But again, the convo on Zoom, like, this is just going to help inform me as to which meetings I'm prepared to do on Zoom and which ones I will not do on Zoom. But it's also got me, I'm wanting to test other softwares because I've realized how useful those transcripts are. once I started getting them through Zoom, that like when I'm trying to prepare an affidavit and now I've got a written transcript. And so I'm editing the transcript as opposed to like starting from a blank page, drafting an
Yeah, yeah,
affidavit.
yeah.
But then because I do a lot of H&C applications, I realized that there's something kind of lost in an affidavit, that what I actually want to capture is the conversation between me and a client, because it's so much more authentic. And like if you're trying to provide a narrative for a refugee claim or for an H&C application where credibility is an issue, when you hear the cadence of the person's voice and they're talking from their own perspective, um, to just record that conversation, have it turned into a transcript, and then be able to produce that transcript at, like, you can attach it to an affidavit so that it's a sworn statement. So I'm trying to test software right now that would allow me to reliably record those, securely translate them into a transcript, and then produce them as part of a sworn statement. So that's my kind of thing that I'm kind of investigating. I'm just wanting to see if other people have started doing this, if they have good tools that they like. And again, this is something that I've put out as an assignment to my IT folks, whose data, who does this well, which data can I be secure with, in terms of where it goes, and just what others' thoughts are about this.
Yeah, I mean, I've started seeing and asking clients if they want summaries of the meetings. I find the Zoom summaries, like the action steps, are always accurate. Sometimes when I read their other summaries, I think, well, those are all words that were said, but not really in that
Not
context,
that way. Yeah,
um,
exactly.
which is kind of dangerous. But,
For
and it also
sure.
like, it makes me wonder actually, like to what extent if IRCC is using AI to try to summarize applications if the same thing arises where it's like those words were all there, but not in that context.
I'm
Um,
sure. I think
but
we can edit them though. Like I think
yeah,
there
yeah, they
is a
can be edited,
function
but
to
like
edit.
it's still the initial because then you have to think back and be like, did I say that?
Yeah.
I guess AI is I live in ChatGPT.
Yeah.
I live in it. Like I've started tinkering. I tried to use Grok after seeing this video on Twitter of like Elon Musk and Donald Trump dancing to I can't remember which song. And I was like, oh, let's see if I can get any AI images of me, but I don't know. Grok won't do it. But right now I find ChatGPT super useful.
So let's do a session where we talk about like everybody's favorite use in their practice for AI.
Drawing pictures. Like that's not so
I
much in
tried to
practice, I
get
guess in practice or like yeah, like that.
in
People at
practice.
work will say Steve spends too much time drawing pictures with
Yeah.
AI.
I know you tried to make our podcast logo with ChatGPT and I ixnayed that.
Yeah. But I really some of the stuff out like I think it's called Grok, but I don't know if I have full access to it. But they're like, I don't know. It seems like they're making like not realistic, but videos actually involved. Anyway, where the technology go is going
Yeah.
is very interesting. I'm actually on a working group for the federal court on
Oh, cool.
AI. It hasn't met
Ah,
in a while, but it helped draft a
we're gonna
notice
do a
that came
session
out.
on that. Yeah, we're gonna
Yeah.
do a session on that on the at the CLABC.
Oh, neat.
Yeah, coming up in December. Um, yes, like it's sometimes I don't really understand how people are using Chat GPT, so I'd love to hear some examples. But like one thing I remember, I was trying to figure out what the right knock was for something and asking Chat GPT to do like a knock analysis based on a job description and explain why it thought that was the right knock. And then like using that, not like just taking it, but just like, huh, do I agree?
Well,
Um,
so that's an interesting like tidbit because I've started doing that too, where I'll put job duties into ChatGPT and say, what's the knock? And if ChatGPT comes out with a different answer, I'll say we might have a problem because if an officer does the same thing
yeah,
and gets the same
exactly.
answer, there might be an issue.
Yeah, it's just good information to have as to like, huh, have I been thinking of it? Because I already have my own assessment thought up. But then, like, okay, so do I agree? Can I understand the rationalization provided by ChatGPT? Do I prefer it? Do I prefer mine? But it's just good to have that
Yeah.
extra information. So,
And then even if you type something to ask ChatGPT, what am I not thinking?
Hmm,
Or what would you ask? Or
cool.
you are a client receiving these email, what questions would you have that can be answered? Like there's so many use cases
Huh,
for it.
cool.
Yeah, I live
Okay,
in
well, let's do a session.
ChatGPT.
It could be an AMA, like, or it could be like
Yeah,
a live session, to figure out how people what their favorite use for it is in practice.
sounds good.
Okay.
All
All
right.
right. Good chatting.
Good chatting.